Welcome to LawTalk, everyone. In this web series, attorneys discuss the laws and legal processes. With these videos, I hope to give you an unvarnished view of our justice system. Today, I will be speaking with my friend Joe Niven, a family and divorce attorney. Joe and I share a passion for the law. We are involved in several bar associations in New York. Joe is a UPenn grad and just an all-around good attorney. Joe, you are employed with the Administrative Children's Services, correct?
Yes, I started out with the Administration for Children's Services. I was an attorney at that agency for 3 years. After leaving ACS, I was a member of the Family Court Assigned Counsel Attorneys for Children panel for 6 years, and I was a member of the Family Court Appellate panel for 5 years.
Okay, wow. Yeah, so as far as your work with the Administration for Child Services, you want to give us some detail on that? What kind of cases were you involved in?
Child abuse and neglect. So our job was to prosecute child abuse and neglect cases. It
So
wasn't like a criminal prosecution, but our job was to get orders to protect kids. In many cases, we were asking that children be placed in foster care. In other cases, we were asking that one parent or even a step parent, or in some cases a grandparent, be removed from the child's home. In other cases, we were simply seeking supervision over the family.
Okay, Joe, let's talk about alimony, which is also referred to as spousal support or spousal maintenance. Can you tell our viewers how maintenance is determined?
Sure. Well, it's determined based upon a formula, and the formula that's used depends upon whether or not child support will be paid, or the same formula that is used if there is no child support is also used if the payor is the one that is the custodial parent, meaning the payor is the one that has the kids and will be receiving child support.
Right.
And then, so it's up to what's called a cap, meaning that it's calculated up to $192,000 a year of income. And the court can raise the cap. Additionally, the court can also deviate from the guidelines if it determines that one or more factors exist that would justify it.
Right. Okay. So essentially there are three calculations that are done. Okay. The first would be you take the payor. The payor is the person that earns more money. Okay. You take 20% of the payor's income, and then you subtract that from 25% of the payee's income, and whatever you receive is calculation A. Okay, and then calculation B is you take both parties' incomes, you add them, and then you take 40% of the combined income. Okay. Um, and from that amount you subtract the payee's income. It's kind of convoluted. So, but that's calculation B. Calculation C is 30% of payor's income subtracted from 20% of payee's income. Okay, so if people, if the couple have children and there's going to be child support paid, the court is going to take the lesser of calculations A and B. If there are no children involved, then the court is going to take the lesser of calculations B and C. And this is it's difficult to understand, just by hearing someone talk about it. So what the courts have done is they have created a spreadsheet that anyone can access, and you can go on that spreadsheet and you can put in, what your income is and what your spouse's income is, and then you have to subtract some taxes and things like that. And then after that, the spreadsheet will just do the calculations for you automatically. I'm going to share my screen now just to show you what the spreadsheet looks. Okay, so all you have to do is go to newyorkcourts.gov/divorce/maintenance child support tools, and you will get the spreadsheet from there. Here you would put, let's say if you're making 50,000 and your spouse is making 100, oh, that's a million. Okay, so you can plug your incomes in there, and you would have to actually be able to calculate some, like the New York City tax. If you all live in New York City, then how much taxes you pay. Social Security tax and Medicare tax, you have to make these subtractions, and you also have to subtract, these other, if your spouse is paying child support for another child, then that would have to be taken out from his or her income. Okay, and then once you plug these numbers in, then then you answer, okay, are there children? I'm just going to do yes. Is the maintenance payer, the person that's making more money, is that person going to be the non-custodial parent? So we, for purposes of this example, we'll just do yes. Okay. Oh, do you want to calculate this? Okay. Okay, so voila, it's right here. Award of the alimony award monthly would be $625. Okay, and then if you go down here and you enter how many kids, let's say 2 children. Okay, 0. Okay, so now this spreadsheet is also telling me for 2 kids, the higher income earning spouse will pay about $1,900 per month for child support. Okay. All right. All right, Joe. Yeah, so I just wanted to run through that and make sure that people know. Go to newyorkcourts.gov and search for maintenance calculator, and you'll find it. All right, Joe. So what happens, and we get this a lot, what happens if one of the spouses has never had a job? So what happens in a situation like that?
Well, the court's going to look at whether or not there's any reason why that spouse cannot work. If the court finds that the spouse can work and simply is choosing not to, they can do what's called impute income, meaning do the calculations not based upon income of 0, but based upon that person's what's called earning capacity, meaning what that person is capable of earning. So we often see here in New York City is that given that we have a $15 an hour minimum wage, that the court will calculate it based upon income of a little bit over $30,000 a year, because that's what the person would be earning if that person earned $15 an hour, 40 hours a week. Then there are other cases where it could be more complicated, where even though that person has never had a job, that person is actually capable of earning more than the minimum wage. Like, for example, if that person has some kind of job training or has a college degree, in which case the payor might want to hire what's called a vocational expert, somebody who can actually provide expert testimony on what that person is capable of earning.
Right, right. So, but if you never had a job, I mean, you still have the court is still going to assign income to you.
In most cases, yes.
In most cases, yeah. I mean, but again, when we say in most cases, it doesn't mean so. I mean, if you still have school, school level children who are, I don't know, elementary school and who still need a parent at home, in a situation like that, the court is not going to assign any income to you. I mean, if they did, I would argue that it's not, if that in that situation, it would not be proper. However, if there are no children or the children have grown, and they're maybe high school age or older, then in a situation like that, we may be looking at some of what we call imputed income. Okay, imputing income is another way of saying the court is going to assign income to you. Okay, and what about a situation, and I get, a lot of angry spouses who do not want to pay anything to the person they hate now, often threaten to quit, to not work, go, where are you going to collect it from there? So what happens in a situation like that, Joe?
Well, the court can also impute income to the payor based upon his or her earning capacity. So if, let's say, the payor was making $150,000 to $200,000 a year,
Right.
and then right when the other spouse files for divorce, that person quits his or her job, then the court's going to know that he or she is capable of earning $150,000 to $200,000 a year and is likely to do the calculations based upon that.
Now, what happens, and I have, what happens when your client or your client's spouse has a business that deals mostly in cash? Um, what happens?
Well, the easiest way to figure out what that person's income likely is based upon the person's expenses.
Right.
So in a contested divorce, um, both parties have to submit what's called a statement of net worth, which lists both parties' income, expenses, assets, and liabilities. Now, if you look at somebody who says that he or she makes $30,000 a year, but has $5,000 a month worth of expenses and no debt, the court is going to assume that that person gets that income from somewhere, is earning at least $5,000 a month. In other cases, it can get more complicated. So one example might be if somebody owns a business and runs a lot of personal expenses through the business, in which case one might have to hire a forensic accountant to figure out what should be added to that person's personal income and what is legitimately a business expense.
Right.
Now, in other much more complicated cases, and this is really reserved for the most complicated case because this can get very expensive, is what's called a lifestyle analysis, where somebody will actually determine what someone's income likely is based upon that person's lifestyle.
Right. And by the way, cash or not, um, during the discovery phase of the litigation, the attorneys will be asking both sides for bank statements for the last 3 years and every month, not just like one statement per year. Monthly bank statements for 3 years, monthly credit card statements, everything. So in a situation where I know that my client does not, just does not want to go and spend more money to do a business valuation, which can be expensive, or on, hiring these extra other professionals to come in and do a full analysis. What I will do is I personally will go through every line item of every credit card statement, of every, bank statement, and I, and the client and I usually will come up with a spreadsheet and we'll just send it on to over to the other side and say, hey, I mean, this is what we're looking at. All right, we can litigate it, fine. If you want, we can litigate it, but then I'm gonna, have to ask the court for counsel fees because all of this stuff was laid out to you before we've had to incur all of these costs. And a lot of times, like things like this will kind of bring about settlements, which clients like because that's hopefully hopefully a good settlement, obviously. Um, okay, so can we just tell people why do we have alimony in the first place?
Well, This is a little bit outdated, but the way that it came about a few decades ago was that we had couples where where usually the husband went out and made a living, and where the wife stayed home and was the homemaker and raised the kids. So nobody wanted a situation where the husband could get mad at the wife and leave her destitute. So the purpose of alimony was to make sure that people that had always been homemakers and full-time parents could support themselves.
Right.
Today, it's pretty different because that kind of situation is not as typical. So what we see is, first of all, where we have somebody that might have been out of the workforce for a few years, maybe somebody who chose not to send children to daycare or to get a nanny, instead chose to
Right.
stay at home with the children
Right.
while before the children started school. And clearly their earning capacity was lower based upon that. It could also be a situation where a child is disabled and one parent needs to stay home. And if they end up going their separate ways, then we need to make sure that the person staying home with the child is able to support him or herself. And it could also be a situation where um, one parent earns significantly more, where one spouse earns significantly more than the other parent, and where it simply would not be just to have one parent all of a sudden have a very, very different lifestyle from the one that that person had
Right.
during the marriage. And there are other cases where one parent might also have some limitations and not have an earning capacity that somebody of their age might typically have. Like, for example, that person has, if a spouse has a disability,
Right.
then the court may very well direct that the other spouse pay maintenance to that person. This way, that person is able to support him or herself.
Right. Right. Yeah, so I mean that's in a nutshell is correct. I mean the laws came about because there was a time where women mostly stayed home and took care of the children, and the men went and built up their careers or their businesses or whatever they did, and when time came to split, um, the wife would not have sufficient income to take care of herself. Like these laws were kind of a remedy for that. And of course, things have changed drastically, but also, Joe and I, we're both parents, and we know, my kids are young, like 8 and 6, and Joe's is younger. But we know that, at least until junior high school or high school, like the kids need somebody there, and if you are a family, or if you are people that care about your family and want to do the best, just like most of us are, right? So one of the parents is going to have is takes the back seat. These days it may not be the wife all the time, although I think largely it still is,
Mm-hmm.
at least from my own experiences. Largely, I think it still is, but again, it's just not the rule anymore. All right, and now I'd like to say thank you, Joe,
Thank you for having
for
me.
participating today. Your insights were wonderful, and I know you do an exceptional job for your clients. And to our viewers, thank you for joining. Please join us for our next episode. Thank you.
Thank you.